start. The unsuccessful SAC is the appearance in this appeal by special writ which arises from the judgment and order of the division bench of the High Court of Kerala in ITR number 15 of 1990, passed on October 22, 1991. By the impugned order, the High Court answered the following two questions referred to it at the instance of the appellant in the affirmative, that is against the appellant and in favor of the revenue, within bracket 1, whether on the facts and in the circumstances of the case that tribunal was justified in holding that there was evidence before the Commissioner of Income Tax that the assessment order was erroneous and prejudicial to revenue, whether on the facts and in the circumstances of the case the tribunal was justified in holding that rupees 3,66,649 was a taxable receipt for the assessment year 1983-84. The facts giving rise to these questions may be noticed here. The case relates to the assessment year 1983-84, for which the accounting period of the appellant ended on February 28, 1983. The appellant is a public limited company. It entered into an agreement for sale of the state of rubber plantation measuring acres 699 of land for consideration of rupees 210 lakhs with Messrs. Supriya Enterprises, within bracket for short the purchaser. On July 18, 1982, the agreement provided inter alia for payment of the consideration in installments as scheduled therein. However, the purchaser could not adhere to the schedule, and on his request, the parties agreed to extension of time for payment of the installments on condition of his paying compensation, damages or loss of agricultural income and other liabilities in a sum of rupees 3,66,649. Accordingly, the appellant passed a resolution also to that effect on September 25, 1983, and the purchaser paid the said amount in the annexure to the return filed by it for the assessment in question. The amount was noted as compensation and damages for loss of agricultural income. By order dated October 31, 1985, the income tax officer expected the same and endorsed nil assessment for that year. The Commissioner of Income Tax, having examined the records of the assessment, found that the nil assessment order passed by the income tax officer was erroneous and it was prejudicial to the interests of the revenue. He issued notice to the appellant under section 263 of the Income Tax Act, within bracket, for short, the act to show cause why the order of assessment should not be set aside, and rupees 3,66,649 should not be assessed under the head income from other sources para. After the appellant filed its reply, the commissioner, by order dated February 8, 1988, concluded that the said amount was unconnected with any agricultural operation activity and was liable to be taxed under the head income from other sources. Dissatisfied with the order of the commissioner, the appellant filed an appeal before the Income Tax Appellate Tribunal, which was dismissed on August 5, 1988. Stop.